Hello, everybody. My name is Dr. Ryan Galloway, and now I'm going to talk to you about debating Supreme Court cases on the negative. You probably want to listen to the affirmative lecture first to get a grasp on how the Supreme Court works and what would be some popular Supreme Court cases on the topic, and then come back and listen to this lecture on how you debate the court on the negative. So, the first primary negative argument against a Supreme Court case is the legitimacy disadvantage. And as I allude to in the affirmative lecture, the Supreme Court actually has no ability to enforce its decisions. So Alexander Hamilton said the court would be the least dangerous branch because it possesses neither the purse, it has no money to enforce its decisions, and it has no military to enforce its decisions. So if other branches of government or the states decide not to go along with the Supreme Court, then their decisions go unenforced. And now, while it's usually the case that the Supreme Court is listened to, there have been times where it hasn't been listened to. So after Brown versus Board of Education, which desegregated the schools, certain states like Arkansas said, we're not going to do that. We're not going to integrate our schools. And the Eisenhower had to send the National Guard to Arkansas to protect children so they could go to school and not be harassed by people and actually have the decision of Brown v. Board of Education enforced. So the Supreme Court relies 100% on its legitimacy, its trust, its reasoning behind its decisions. And the theory goes that controversial decisions will sap the court's legitimacy. If something is controversial, then the court won't be perceived as legitimate. And I'll talk more about this in the court capital disadvantage, but there are reasons to think this current court might not be very legitimate. And so if you think back to McConnell not allowing Barack Obama's appointee of Merrick Garland to be voted on by the Congress, that looked like a partisan political maneuver. And courts are supposed to be above politics. The reason why Supreme Court justices are appointed for life is because theoretically their decisions should not be political in nature. And if the court looks like it's just another political branch of government, that there's nothing different about the court than the Congress or the executive branch, then that unique legitimacy, that unique standing that the court has in the country will be decreased. You can argue that the court needs to stand up to the president. You could argue that the court needs to stand up to Congress. You could argue that a legitimate court is needed to protect the environment. There could be all kinds of impacts you could run to the court. The more popular variant of legitimacy, at least in debate circles, is the court capital disadvantage, sometimes called court politics. So some theorize that the court has a certain amount of institutional capital that it can use, that it can only make so many controversial decisions. And a lot of people think that John Roberts, the Chief Justice of the Supreme Court, is very concerned about the institutional capital that the court has. And he doesn't want to make too many liberal decisions, and he doesn't want to make too many conservative decisions because he wants the court to look politically neutral. And there's a good amount of literature after the Obamacare cases. So you may recall that Obamacare came before the Supreme Court, and the question was whether or not the individual mandate of Obamacare was considered constitutional or not. And John Roberts actually, who is a conservative justice in theory, actually sided with the liberals. And a lot of people think the reason why he preserved Obamacare was because he didn't want to make a ruling against the President of the United States. So if the plan was a controversial ruling, then the court might make other decisions that are not as controversial, or if the plan is liberal, they might make a conservative decision to sort of offset it to where they didn't look like a partisan branch of government. So the court doesn't want to look bad, so they'll only make a certain number of controversial cases. And you'd run specific upcoming court cases as disadvantages. And so you'd find a case on the docket that is uniquely controversial, and if the court ruled the way it did on the plan, they might not rule the way they want to on another court case because they don't want to look partisan, they don't want to look bad. Now, this is at odds with the theory that the court doesn't respond to politics, but I think more realistically, you'll find evidence that says the court, just like any other branch, doesn't want to look bad. They don't want to lose their perceived legitimacy in the eyes of the public, and so they will only do certain things. Another disadvantage which may be popular on this topic is the court clog disadvantage. And when I've done some research on the Waters of the U.S. case, that if the Supreme Court came in and decided a certain way on the waters of the U.S., that there would be a flood of lawsuits from various states that want to test the limits of what they are allowed to do under the waters of the U.S. and what particular streams and what particular rivers and what particular wetlands are considered to be under federal jurisdiction under the waters of the U.S. The idea is the plan would cause a flood of new cases, that a bunch of people would sue under the plan, and they would sue at the state level or they would sue under the federal level to try and figure out what the new ruling meant. This would then overload the court system. There would be too many cases. The lower courts would not be able to decide all those cases. The backlogs would become significant to where cases wouldn't be decided for a long time. And two impacts to that disadvantage you can run are, first, it undermines the economy because businesses need certainty in decision making, and if cases begin to get delayed, there isn't as much certainty, which undermines the economy. It could undermine solutions to terrorism because we need to try terrorist suspects quickly. It could potentially undermine solutions to immigration. It could potentially undermine solutions to the environment, etc., because the courts get clogged. The next disadvantage I want to talk about is the hollow hope, which is named after Gerald Rosenberg, who is a professor of law at the University of Chicago. And his argument is the courts are bad for social change. So the question of the book, the name of the book is, can the courts produce social change? And the answer he comes up with is no. Courts cannot produce social change. The argument is that courts are flypaper for social movements. Big symbolic cases suck them in. So let's say the Supreme Court comes and they make a case that protects the environment, like the Waters of the U.S. case. Then other environmental groups might say, hey, we should also go through the courts instead of the Congress or instead of state legislatures because the court has just been successful. Well, if you get stuck in the court like flypaper that is sticky, then you will not be successful. And the movement gets hurt because the court is bad for social change. The impact could be the environmental justice movement. The environmental justice movement was heavily involved in the Flint water case. And so if someone came in and made a racial justice decision through the courts and said we need to protect minority rights to water, then environmental justice movements would go to the court, they would get stuck, they would get hurt, and that would undermine the movement. Or the climate change movement. The climate change movement has been growing in the United States, especially among young people who are concerned we're polluting the environment. A lot of young people in the United States are following Greta Thunberg and her international movement of youngsters to try and stop climate change, and if the court is a bad vehicle for the climate change movement, then the climate change movement could be stopped dead in its tracks. The next kind of disadvantage to talk about is court stripping, that the Congress could limit the ability of the court to hear certain cases. So Congress actually has the ability to control the jurisdiction of the court, what kind of cases the court can hear, and if the Congress gets angry with the courts, they will strip it. They will deny it of the ability to hear certain kinds of cases, which can undermine the court's ability to function and cause problems internationally. If the plan is modeled, other nations' legislatures would not allow the courts to hear certain kinds of cases. The next disadvantage, which is actually a net benefit to a counterplan, is reverse politics. So what someone would do is you're debating against a Supreme Court case, and you run that Congress should do the affirmative plan. By doing the affirmative plan, Congress would trash the president's power. So you run a politics disadvantage where triggering the impact is good. You would say Biden is bad. We need to hurt Biden. The counter plan hurts Biden. And then you argue that the permutation and the plan alone shield the link, preventing the good impact from happening. So the affirmative team will try and say, well, we also trigger the politics disadvantage. And then the negative says, no, the courts would shield the Congress from the politics disadvantage, so your permutation doesn't trigger the link, and courts alone won't trigger the link. Only the counterplan triggers the link. Only the counterplan triggers the net benefit. The affirmative plan and the permutation will not trigger this net benefit. So an example of reverse politics, you could say the infrastructure bill will pass now, and the Congress counterplan would tank the infrastructure bill. Biden would lose his political capital because he would pass the plan through Congress. Congress would backlash against Biden and tank the infrastructure bill. And then you'd say the infrastructure bill is bad. If the affirmative argues that the court's case of their affirmative or the permutation triggers the link, the neg argues that the courts shield the link, and therefore only the counterplan hurts Biden and stops the bad infrastructure bill from passing. The next counterplan is the constitutional amendment counterplan, which would amend the U.S. Constitution to take the same action of the plan. And it would argue to capture the signal of the court decision. And the net benefit is court capital. Arguably, a constitutional amendment hurts the court's institutional capital less than an overruled decision by the Supreme Court. It would be better for the elected branches of government to amend the Constitution than it would be for the Supreme Court to strike out on its own and come up with a new interpretation of the Constitution. So it would be better to have a constitutional amendment. The next thing I'm going to talk about is a court-specific critique called CLS, or Critical Legal Studies. Critical Legal Studies says the law is inherently biased. A certain variant of critical legal studies is CRT, or critical race theory, and I am somewhat humored by the idea that critical race theory has all of a sudden become very controversial in the United States based on warped interpretations of what critical race theory does, which was originally a movement in the law that said the law was meant to uphold white people and not education systems, etc. But anyway, critical legal studies or critical race theory says the law is inherently biased. Critical legal studies says it's biased towards wealthy people. Critical race theory says it's biased towards white people. It doesn't matter what the law is. Judges will manipulate the law to bolster the rich. So you can make the law change to whatever you want, and the law will be indeterminate. That there are so many precedents on the books that judges can come up with whatever conclusion they want. They could just cite different precedents, they could come up with different judicial reasoning, and they can do whatever they want, which means no matter what precedent you think you're setting through the Supreme Court, it will be ineffective because the law is indeterminate and it will make no positive change. It is bad to uphold the law and make it look good. You shouldn't mask the law. We should operate through grassroots movements. So I've talked about disadvantages to Supreme Court action. They are different than other kinds of disadvantages, and you should be familiar with them. I've talked about a couple of different types of counterplans you can run, the Congress counterplan and the Constitutional Amendment counterplan and their net benefit. And I've talked about at least one specific case of the Supreme Court, which should give you some arguments you can run against Supreme Court cases, which could be very popular on this topic.